Good morning to everybody. My name is Diane Desierto. I am professor of law and global affairs and director of the Human Rights LLM program at the Notre Dame Law School with a joint appointment at the Keough School of Global Affairs. I am also currently the chair rapporteur of the expert group on the right to development at the United Nations. And so the topic of human rights and intellectual property rights in particular is something deeply concerning from all the hats that I wear, but also primarily from the most hat that I wear, which is from being a person from a developing country myself who has experienced and continues to experience the ongoing disparities and consequences of the disparities and inequalities surrounding access to needed vaccines as well as therapeutics and other pharmaceutical remedies for the ongoing pandemic, or I should say probably at this point endemic in the rest of the world. We have a talented panel of experts who are available today. What I will do is briefly introduce our three panelists and then proceed to discuss at least some initial thoughts as to why we're focusing on a panel involving how to implement human rights appropriately, especially considering the paradigm of incentives in the intellectual property rights regime and how that could work and how cooperation could be built and where certain log jams exist in making the kind of decisions that we have to make in regard to the legal structures that drive innovation for purposes of obtaining the necessary medical and pharmaceutical relief for global public health, especially in a time of crisis and pandemic. So we have in our panel today, we're very lucky to have Ruth Okediji, who is the Jeremiah Smith Jr. Professor of Law at Harvard Law School and the co-director of the Berkman Klein Center. She's a very renowned scholar in international intellectual property law and the foremost authority, at least in my view, on the role of intellectual property in social and economic development. We all read Professor Okediji's work. She is very well known as having advised intergovernmental organizations, regional economic communities, and national governments on matters that involve the intersections of technology, innovation, policy, and development. And her scholarship, at least also from my own knowledge here, has influenced many government policies in sub-Saharan Africa, the Caribbean, Latin America, and South America rather, and has also helped strategies for the implementation of the World Trade Organization's agreement on trade-related aspects of intellectual property rights. And she works closely with United Nations agencies, research centers, and other organizations on the human development effects of international IP policymaking, such as access to knowledge, access to essential medicines, and issues related to indigenous innovation systems. So my welcome to Professor Okediji, Ruth, if she is on the chat, but right now I'm not seeing her in the list of participants. Let me move next to introduce our two other panelists. Our second panelist or second speaker is Professor Jorge Contreras. Professor Contreras teaches intellectual property law, and genetics and the law at the University of Utah, where he is professor of law. And he's also named as one of the University of Utah's presidential scholars, having also received distinguished awards from the College of Law and the university's Distinguished Research Awards. He has an extensive background in practice and in scholarship. He has served on the law faculties of American University, Washington College of Law, and Washington University, St. Louis, was a partner at the international law firm William Cutler Pickering Hale and Dorr, where he practiced international transactional and intellectual property law. His research, and one that might be of deep interest to everybody in this call, is in particular on the open COVID mechanism that he proposed, co-proposed and developed together with Professor Mark Lemley at Stanford. And that has something to do as well, in particular, with the access to knowledge dimensions of intellectual property, which also correspondingly has human rights implications when we're thinking about how to truly implement the right to the highest attainable standard of physical and mental health. So Professor Contreras, welcome as well for joining this panel, and my thanks for agreeing to make your presentation today. And finally, we have Professor Srividhya Ragavan, who is Professor of Law and Director of India Programs at Texas A&M University, where she draws from her experiences, particularly expertise in legal practice in India, as in-house counsel at two of their largest Indian multinationals, and also having worked as legal consultants for various enterprises in India. And to the extent that there's a very specific interest in looking at the developmental perspective in relation to intellectual property and the trade regime, we would be definitely interested in how Sri would look at, as she has discussed with us, the possibilities of looking at the public health treaty and how that could be an additional sort of institutional dimension to take a look at the intersection of human rights and intellectual property law. So in sequence, if Ruth is on the call, I don't see her right now, but perhaps she's going to join us in a few minutes. Perhaps I can begin with first setting up this question. I mean, in the first instance, when we look at human rights and when we look at international and in particular intellectual property law, they're both bodies of law, both binding on states. And to the extent that there has been a persistent tension in how to realize and first understand the human rights concerned and how to implement them to achieve them within the specific context and regulatory framework of intellectual property, this has arisen in rather a sharp contrast in the context of this ongoing pandemic over the last couple of years. The rights that we're speaking of are all interrelated, indivisible, and interdependent human rights. We talk of fundamentally a right to life. We also talk of the right to the highest attainable standard of physical and mental health, and who makes those decisions. Is it solely the person, the bearer of the right, or is there room for authorities, whether it's the intellectual property authorities or the health authorities, to weigh in on the kind of decisions and autonomous decisions that individuals can make in regard to what their desired level of health and their desired level of risk tolerance will be given their individual context and circumstances. There's also related rights that fall under the social determinants of health, such as the right to an adequate standard of living, the right to water, the right of access to water, the right to food security, the right to housing, all of which bear on more or less the indivisibility and interdependence and interrelatedness of human rights. The challenge of translating human rights within the spheres of economic decision-making, one of which is the design of incentives in the patent protection system in intellectual property, is also a challenge, first and foremost, of determining the audience and determining the authority. And why do I say this? First and foremost, it's common parlance to think in international human rights law as simply the assertion of a right as opposed to other actors within the ecosystem. And that right could potentially give rise to a violation if the right's core elements are not met. But this is where distinctions have to be made. For example, when we talk of economic, social, cultural rights, such as the right to the highest attainable standard of physical and mental health, this has to be read alongside three cross-cutting obligations: the legal obligation not to discriminate and to ensure that the state party that is a party to these human rights treaties, specifically the Covenant on Economic, Social, Cultural Rights, the state does not discriminate in its policy and its programming in a way that prejudices the right, the realization or the implementation of the right. The second is the provision of a minimum core of what is expected from the right. So when we talk about a minimum core in the right to health, in the particular context of the provision of essential medicines or vaccines or therapeutics, are these uniform questions? They can differ case to case, especially on a developmental standpoint, when resources are vastly inequitable between the global north and the global south. And that is an ongoing dialogue, at least, especially when we try to think of how non-discrimination operates and also how the minimum core obligation operates. And finally, there is, quite contrary to popular perceptions, there is a duty to participate, or to cooperate, to realize human rights, which is probably the most underrated and underobserved duty these days in an era of tribalisms, in particular over resources in the fight against COVID. There is a duty on the part of states to cooperate insofar as what in achieving the necessary international aid and assistance, whether it be through technical, legal, fiscal matters, to ensure that all of these economic, social, cultural rights are realizable or can be progressively realized by states in a manner that is consistent with all available means at their disposal. The dimension that has not been amplified, at least for purposes of this, what do you call it? For the purposes of realizing the right to health in different contexts around the world, is that often when one starts drilling down into the specificities of the international regulation of international intellectual property, when we look at patent law, when we look at the specificities of regulations in trade law, human rights is often difficult to translate, and what that duty to cooperate means in the particular context of IP law falls into the contours of the specific body of law. So in terms of epistemic communities, the question often for human rights lawyers is, how do you translate this right, which is supposed to be a right that allocates or that guarantees and safeguards the highest attainable standard of physical and mental health? How do we do that, not just from the standpoint of our individual conceptions of what that highest attainable standard is, but also for purposes of determining who implements it, which state party, what's the nature of that cooperation, and how does that play out when there are pre-existing obligations, particularly under patent law? And probably insofar as, at least for me to wrap up on these issues and to proceed to our panelists, the last thing I myself would be definitely interested in considering from the standpoint of human rights and incentives, and how we could possibly shift incentives in the way that they've been designed in the international intellectual property system, is to take a look at the right to development, which under the 1986 Declaration on the Right to Development has been acknowledged as customary international law in many contexts. There is supposed to be a right to participate of peoples, a right of individuals and peoples to participate, contribute, and enjoy economic, social, cultural, and civil development. And in the pending draft convention on the right of development, that development should be based on and premised on and consistent with all human rights and fundamental freedoms. This purposely places the lens of human rights front and center in the evaluation of development decision-making. So to the extent, therefore, that for quite a long time, IP law and international IP law has looked at itself as a fairly self-contained legal regime, can it still do so if development decision-making, if the right to development, if that is supposed to be subject to the lens of looking at consistency with fundamental rights and fundamental freedoms and human rights? So I think let me end there and proceed first and foremost with,
Yes.
indeed, let's start with Professor Contreras. Welcome, Professor.
And so thanks very much for inviting me here to talk about this project that I worked on with a number of people, including Mark Lemley, as you mentioned, but also quite a few others who I'll mention during the talk. And I do have a few slides. I won't belabor them, but I think it may be helpful to illustrate some of these points. And I will give you a disclaimer at the beginning. I am not a human rights expert. I'm an intellectual property lawyer and scholar, and but hopefully this mechanism that I'll describe will provide a tool that others can use and consider in the pursuit of human rights issues. So hopefully everybody can see the screen. And just very briefly, the genesis for this project was a number of news stories that began to come out early in 2020 as the COVID-19 pandemic began to spread around the world. And these were stories about ways that intellectual property was posing a barrier to the dissemination and supply of not only drugs and vaccines, those did not exist at the time, primarily hospital equipment, ventilator parts, masks, PPE, diagnostic kits, and so forth. Some analyses done by my colleagues at Cambridge University looked at the number of patents covering various fields of endeavor necessary to respond to the pandemic, and they found essentially, these charts are very detailed, but they found large numbers of patents and other IP covering many of the areas that were necessary to respond to a pandemic. And so you probably all know that there are numerous intellectual property mechanisms that have been called upon and are traditionally called upon in emergency situations like this. I will not talk about the first two of these, which are very well known and have gotten a lot of attention lately: compulsory licensing and the formation of intellectual property pools and clearinghouses like the medicines patent pool. I'm going to focus on this third one, patent pledges. And so what are pledges, right? They are voluntary mechanism, right? They're voluntary public commitments made by patent holders to limit the enforcement or utilization of their patents, not to eliminate their patents entirely, but to offer limitations on enforcement without any sort of direct compensation. And the most famous of these pledges was made back in 2014 by this guy, Elon Musk, who most of us probably know, with respect to Tesla, his electric vehicle company. And he basically said that Tesla would not bring patent lawsuits against anyone who wanted to use its technology. Made quite a splash at the time. But patent pledges, of course, are not limited to the automotive industry. They appear in a wide variety of industries, particularly the software field. Technical standards are widely covered by these types of pledges, green and clean technology, and even some biotechnology. There's a lot of writing and theorizing about these types of mechanisms. Are they legally enforceable? In short, I think there are very strong arguments to make for their legal enforceability under various theories of contract law, estoppel, even some antitrust and competition and property theories can be brought to bear. And we certainly have precedent in areas like technical standardization and open source code software, in which courts around the world have recognized these types of commitments as legally binding. Why do entities who hold IP make these commitments? So there are a number of reasons, and various papers, including several that I've written in the past, try to parse the motivations that entities have for making these types of pledges. If you look at somebody like Tesla Motors, who was followed by Toyota in making pledges around non-gasoline powered vehicles, they are largely attempting to draw the market toward a particular technology that they favor, a particular platform, whether it's a Linux operating system or possibly hydrogen-powered vehicles, electric battery-powered vehicles, because they operate in that market and they are facing competition from often much larger interests like the gasoline and petrochemical industries that are very difficult to overcome. There are collective action motivations. There are motivations around voluntarily restricting your ability, handcuffing oneself to appease government regulators. And we'll talk about that in just a moment. And then there are mission-oriented rationales, either purely philanthropic or tied with corporate social responsibility goals, employee satisfaction goals, and so forth. So a range of economic and corporate motivations for doing this. So when COVID-19 emerged at the beginning of 2020, a number of holders of IP unilaterally pledged their IP assets, or some of them, to the fight against COVID-19. Medtronic and Smiths Group, large manufacturers of hospital ventilators, did so. The Wellcome Trust on the copyright side assembled many scientific publishers to make their COVID-19 related research publicly available. The IGI at Berkeley, AbbVie, the pharmaceutical company with respect to this drug Coletra, and Fortress, which is a patent assertor, which was kind of publicly shamed into making a large portfolio of patents publicly available. That said, these are all unilateral and one-off efforts. And so in March of 2020, a group of us got together to think about ways that we could possibly create a standardized platform for allowing IP holders to make these types of commitments without reinventing the wheel every time. We look to models like open source code software, the Creative Commons suite of open content licenses, and had some design goals in mind. We wanted something that was going to be legally enforceable, of course, something that would be attractive enough to the holders of IP, but also that would result in a broad dissemination of whatever the pledged technology was. And like good engineers and designers, we came up with some design principles that we wanted the thing to be simple. We did not want 20-page long contracts that had to be signed individually. We wanted whatever this framework was to be uniform, like the Creative Commons licenses and open source code licenses. We wanted it to be easy to execute, executing simply with a click or simply by use of whatever the intellectual property was without the need for negotiation or signed contracts. We wanted the scope to be limited, that is not to ask IP holders to give up their IP entirely, but to contribute it for a specific purpose, only the COVID-19 pandemic. And of course, we wanted it to be at no cost. When you introduce a cost element into any of these licensing schemes, the complexity increases by at least an order of magnitude. Many have asked us, why not just ask IP holders to contribute their IP to the public domain? And there are numerous reasons why we didn't do that, and why IP holders expressed to us that they wanted to hold on to their IP for a number of reasons, including defensive use. Right, to if you give up your IP, then if somebody else sues you for IP infringement, you have nothing to fight back with. And many large IP holders today hold their IP primarily for defensive purposes. Also, companies are valued based on the size of their IP portfolios. The fact that you've pledged or licensed your IP for broad use, ironically, doesn't really affect portfolio valuation. The number of IP assets that you have does. The limited duration and scope of the pledges was also quite important, and giving away your IP or contributing to the public domain makes it available in all fields, but if you only give up usage in one field, say COVID-19, then you retain the rights in other fields such as AIDS, HIV, medication, and so forth. This was the case with AbbVie and Coletra. It basically pledged use of Coletra as a therapeutic against COVID-19, but it was primarily an AIDS drug, and AbbVie was not willing to give that up. And then finally, the lesson that we have from open source code is that if you voluntarily give away your IP, then nobody has the ability to enforce it against those who are violating the terms on which it was given up. So there are a number of reasons to hold on to the IP. So this is what we came up with, a pledge, basically a short one-sentence statement that whoever the IP holders were, they would make their IP available free of charge for use in ending the COVID-19 pandemic and minimizing its impact. Like the Creative Commons licenses, which are also very short and tied to little symbols, behind all of this, there is a longer legal document that those who are interested can read. Principal terms of that document are still fairly straightforward. They describe the license rights, but are only patents and copyrights. There is, of course, today a large debate over vaccines and vaccine manufacture and the trade secrets that are necessary to enable that. We did not, in this mechanism, opt to require the transfer of know-how or technical trade secrets, because that involves a significant resource commitment from the IP holders and deterred IP holders, right? The pledge was intended to be something very easy for them to undertake, and they could, of course, follow up with technology transfers if they so desired. The field, again, we wanted to limit it to COVID-19 and not cover all diseases or indications. We wanted the term to be limited, again, so that IP holders did not feel that they were giving up the entirety of their IP asset. So it has a limited term during the duration of the pandemic, plus a 1-year ramp down with an outside date. We, of course, had to tie the pledge to any regulatory exclusivities that might be afforded by the US Food and Drug Administration, the European Medicine Agency, and so forth. We allow defensive suspension so that if one is attacked in an IP suit, they can then take back the license that was granted to the attacker, and we allowed for some customization. We also omitted a number of things that traditionally appear in licensing agreements in order to more streamline and simplify the grant, all of the typical warranties and indemnifications and so forth, but also substantive provisions like grant backs, share alike, or what in the software world is called copyleft provisions, and downstream pricing constraints. These were, we talked about these for quite a while, and they're somewhat controversial, but we felt that requiring that users of IP abide by any kind of pricing constraints would disincentivize users to make use of the pledge technology. And in this emergency situation, our design choice was to achieve the broadest dissemination possible and not to attempt to constrain pricing in the downstream area. Again, could have come out differently, but that was the design choice that we made. This was the result. Interesting, you know, again, this is something of an experiment. We did not know what to expect. We did get a large number of pledged IP assets. We estimate about 500,000 patents pledged by, but mostly by the high-tech sector. Companies like Facebook, Amazon, Intel, IBM, Microsoft, Hewlett-Packard, Uber, and the like, who have large patent portfolios, primarily operating in the high-tech and IT space. Some small, medium enterprises, 2 US national laboratories, 1 university, and some coalitions that are operating together. There was a similar pledge activity that was operated in Japan. Also got a very large following from Japanese industrial companies. So the real question now, I think the pledging activity has wound down. So we undertook some analysis of what happened here using a 5-category taxonomy developed by Frank Tietze at Cambridge around the types of IP that are what he calls crisis critical IP, from biopharma to diagnostics to equipment to PPE to digital innovations. And I won't go through these in laborious detail, but there is a paper that is out now in the Utah Law Review that goes through these in far more detail. In short, we had a lot of pledging in the areas of digital innovation, from research tools to models and contact tracing, epidemiology, infrastructure, logistics, and even information and misinformation tools. There was a large amount, and some of the primary holders of IP in these areas pledged it to the COVID-19 response. In terms of PPE, the national laboratories, Sandia and the Jet Propulsion Laboratory, had significant assets around personal protective equipment that were made available free of charge. I mentioned the ventilator companies already. Also, some smaller medical device companies were part of the pledge. In the diagnostic space, there was some intellectual property, surprisingly held by companies like IBM and Intel, but also the national laboratories and the Yale portfolio inherited by Fortress from Theranos, the defunct blood testing company. And then we have the biopharma space, which is where most of the debate today is occurring. It's an area in which the least amount of pledging occurred, not surprisingly, and I'll talk about that in just a second. There was some, most notably Moderna, the mRNA vaccine developer and manufacturer, did pledge its patents to the COVID-19 response. Okay, so why was biopharma the last or the least pledged area? I mean, I think it's not surprising at all that this is the case, given the large amounts of money at stake in this field, the large amounts of money that governments are willing to pay and pay in advance for these products, the investments that were large, that were required in this area. And because in a voluntary system like this, there is no penalty for refusing to participate. One area in which we thought we might gain better traction was universities, and we have cooperated with UAEM, a student-run group, Universities Allied for Essential Medicines, came out of Yale University in the early 2000s and is now a worldwide organization that mounted something called the Free the Vaccine campaign that adopted the Open COVID Pledge as the preferred method for universities to make their IP available. And largely they did not join this. There is a university pledging effort led by Stanford, Harvard, and MIT, to which about 20 universities around the world signed up, a very small number. But unclear how many licenses have actually been granted under that program. I would love to find that out if anybody knows. However, I mean, I think in our final analysis, this exercise has demonstrated a number of things. First, that even below 100% coverage in a particular field, pledges, if there is a significant enough activity in the pledging area, they can clear the field of patent risk and make certain fields characterized by less patent assertion. And even that partial clearance can reduce inhibitions about innovation in a field or new entrants entering a field, signaling that a field is open to user innovation, something like open source software. But in the areas, for example, of contact tracing, supply management, routing, PPE, and medical equipment, there has been a surprising lack of patent assertion, a type of assertion that you would see in comparable fields like video games and other areas that are in the same general classes of goods that the patents cover. There were numerous prior efforts around pledging that we had the benefit of looking at. The Eco-Patent Commons was one that ran from about 2008 to 2016 that eventually wound down and was viewed with kind of mixed results. And we have taken some efforts and are continuing to take some efforts to try to avoid some of the problems that pledge community faced around a lack of tracking of usage, linking the intellectual property to users, and so forth. We have tried to internationalize this pledge thanks to the efforts of Creative Commons. It is now hosted at American University. We have alliances with both the Japanese group, UAEM, WHO, efforts, and are continuing to explore ways that the pledged IP can be used and has been used, with the ultimate goal of making hopefully a meaningful contribution to the technology bottlenecks that were early identified in the COVID-19 response, but also learning from this to develop a usable framework for future IPR sharing, obviously future pandemics, but also and most importantly, I think, is climate change, where we've already established something called the Low Carbon Patent Pledge that a number of the pledging companies from the Open COVID Pledge have joined: Facebook, Microsoft, Hewlett-Packard Enterprise, and then some new additions such as JP Morgan Chase have joined this. And this is an effort that is sort of still in formation, but we are hoping can achieve some results here as well. So again, I'll I'll leave the slides with you. There's a lot of literature that's emerged and about these techniques lately. And I thank you very much for your time and your patience.
Thank you very much for that, Professor Contreras. We will move on to Ruth now, Professor Okediji, if you may.
This is an issue that I've been thinking about for quite some time, and I think one of the real challenges that the human rights and intellectual property interface has is the lack of a distinctive theory for global welfare. We all of our welfare theories stem particularly from the trade regime and the notion of dynamic efficiencies that we obtain from free trade. And this is particularly problematic in the context of access to medicines because of the tension to which George has already alluded between human welfare and intellectual property, particularly patent rights. There is no governing theory or even approach to reconciling the notion of access to medicines versus access to the free trade regime. So I'm going to start with a little bit of background. We're all likely familiar with this, that Article 27 of the Universal Declaration and Article 15 of the International Covenant on Economic, Social, and Cultural Rights really frame the challenge from the human rights perspective. Everyone has the right freely to participate in the cultural life of the community, to enjoy the arts, and to share in scientific advancement and its benefits. That's Article 27 of the Universal Declaration of Human Rights. And then, of course, Article 15 of the International Covenant says that everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he or she is the author. So we see these rights within the human rights framework, but nowhere are they really replicated in the intellectual property system. And that, of course, means that we are dealing with a challenge that has both legal, political, and economic consequences. The International Covenant, of course, translates the aspirational language of Article 27 of the Universal Declaration. And so one might argue that there are specific legal obligations that states have. States are to take steps that are necessary for the conservation, the development, and the diffusion of science and culture. So that's one way of thinking about these specific legal obligations. The other is that states must respect the freedom necessary to undertake a scientific research and creative activity. So George's really heroic efforts, and I think really important initiative with Mark Lemley on patent pledges reflects, I think in some way, although that didn't come from the state, that was the initiative of private individuals, but nonetheless, it reflects one possibility, or at least an expression of both the freedom for scientific research and the possibility of the diffusion of the fruits of science to the broader community. But the Universal Declaration and the International Covenant, Article 27 and Article 15, really do raise this question about, well, what exactly are the legal obligations that states must support or ensure? Larry Helfer in his work has outlined very helpfully three possible frameworks between human rights and intellectual property: the conflict framework, the coexistence framework, and then a framework that tries to chart a middle path. The conflict framework, for those of you who've read Larry's work, is one that pits the two regimes against the other, and only one can prevail. And then there's, of course, a coexistence framework, which I have been very critical of. And the coexistence framework essentially views the possibilities of harmonizing both regimes with the idea that both have the same basic objectives. And then a third approach beyond conflict and beyond coexistence really focuses on how to restructure IP rules. Can we restructure the rules of the game? Can we interpret or revise the rules to enhance the realization of human rights? And I think the COVID-19 pandemic has raised the stakes for identifying ways in which we can deploy the IP system for the realization of these human rights ends. Now, I think one of the challenges is that in addition to being vaguely worded with respect to what the legal obligations are of states, there also has not been certainty about what the end game is. What are we, from a human rights perspective, attempting to accomplish? Is it just the restructuring of the system? And will a restructured system in and of itself produce the kind of goals that we are looking for? So if you were to think about a winner-take-all approach, which is what the conflicts approach is, this approach really raises the question, well, what kind of conflict needs to exist? What kind of conflict exists for us to be concerned about human rights ends? And if there is a conflict, what's the rule? What legal rule applies? And then third, what is the basis in international law for choosing one legal regime over the other? I think it's important to think about this framework because it really brings to bear the challenges that the intellectual property system faces and the challenges that human rights regime faces when addressing the challenge of access to medicines. What sort of conflict must exist? Is it a conflict of norms? That's certainly not the case. We know this. Is it a conflict over the right of states to utilize compulsory licensing? We know that that right exists. We see it in the TRIPS agreement. It exists and has been reinforced through the Doha Declaration. So this is not a conflict over norms. It's not even a conflict over doctrine. Neither is it a conflict over limits and exceptions to intellectual property. And because we don't see an apparent conflict, it makes it difficult to argue that one regime should have primacy over the other. It also means that we are avoiding the question of, well, what is the basis in international law for choosing one legal rule over the other? And so despite there not being a clear conflict, much of the literature deals with the problem of access to medicines as though there were a conflict. And so the advocacy really deals with, well, how do we avoid or reduce these conflicts? Those approaches, like good lawyers, involve interpreting the text in a way that accommodates limits to property rights. States are encouraged to avoid signing treaties that create patent conflicts, no pun intended, between these two regimes. There are, of course, within the international law system, the Vienna Convention's provision that the later in time rule prevails. And so some treaties have an overriding provision where there are conflicts. And then, of course, the possibility of revising the text. And we saw the Doha Declaration could be an example of textual revisions when the need arises for such to occur. But there are also savings clauses, and Larry typically uses an example from the Treaty on Plant Genetic Resources for Food and Agriculture. For those who might not be familiar with this is a savings clause, the idea that the treaty should be interpreted in a way that's mutually supportive with very specific goals, in this case, sustainable food and agriculture and food security, affirmations that nothing in the treaty should be interpreted as undermining human rights obligations, and understanding that the recitations of these treaties are not intended to create a hierarchy. But whenever the literature really then deals with the access to medicines, there's an argument that the human rights interests ought to prevail. The question is that we don't have a well-conceptualized human rights primacy argument. we think, for example, the right of access to medicines. What does that really look like? Is it an access to the technologies that produce the medicines, in which case that would be the compulsory licensing approach? Is it a right of access to know-how? In which case we have no real mechanism for enforcement, since know-how tends to be protected by trade secrets. Or is it the sort of initiative like the Open COVID Pledge initiative, in which there are rewards, perhaps that states might provide for those organizations and companies that pledge not to enforce their patents? In other words, there could be both a defensive and an offensive use of a human rights approach that could be more usefully broken down into what exactly are the rights directed at. Is it the technologies? Is it the finished medication? Is it a right to low prices? Or is it some combination of all of these? Now, when making the argument about giving a primacy to human rights over IP, almost always it's a very legalistic argument that is made. The UN Charter trumps all of the treaties. The UN Charter requires member states to respect and observe human rights. The Universal Declaration is an authoritative statement of the human rights obligations of the UN Charter. But of course, as I always say, the Universal Declaration cuts both ways. Both innovators and consumers are rights holders under the Universal Declaration. And so the argument that human rights have primacy over intellectual property under international law, in my view, is not the most robust argument that there is. Moving to the coexistence approach, this often always gives weight to modifying existing IP rules. The challenge that we find, and we see this in the COVID-19 context, in the context of discussions about the waiver, is that the modification of IP rules would be occurring in a landscape in which the current modifications have not been utilized. Developing countries, for example, have rarely utilized, especially the least developed countries, for good reason, have not utilized compulsory licensing. We find that many of the other limitations and exceptions that are available under the TRIPS agreement have never been utilized. And some might argue that that's because of pressure from the US or the EU, but it's also, as I've made an argument lately, that these are not mandatory. States have an obligation, both under the TRIPS agreement and also under the human rights treaties, to facilitate the access of consumers to essential medicines. If states don't utilize the existing limitations and exceptions, there is a question as to whether or not what human rights obligations require then is that those exceptions and limitations be made mandatory. In somewhat of the same fashion that we did with the Marrakesh Treaty, in which every member state to the Marrakesh Treaty mandatorily must have an exception for the blind to access copyrighted works. So one question is, we have the apparatus and the Doha Declaration under paragraph 6 solution that has not worked very well. Compulsory licensing has not worked very well. And to George's point about the COVID-19 patents, in the absence of know-how and the transfer of technical know-how, it's unlikely that in and of themselves will work. What the pledges do, however, is suggest that the paragraph 6 complex mechanism could be avoided. And this, I think, is one of the most important facets of the Open COVID Pledge. So the High Commissioner has issued a report on the impact of TRIPS on human rights and has emphasized this coexistence approach. In other words, use the flexibility clauses in the TRIPS agreement that allow for access to essential medicines and other health technologies. Audrey Chapman has advocated using human rights criteria in addition to patentability criteria for granting patents. We've already seen some examples of this in countries around the world using competition law as a filter for patentability, in countries historically like Brazil, using impact on access to the finished medicines as a criteria for whether or not the patent ought to be issued in Brazil. There are countries who do administrative agency reviews in evaluating the impact. We actually in the US do this not from an access to medicines perspective, but we do it with nuclear technology. Every patent that affects nuclear technology is immediately subject to a compulsory license by the US government. An innovator in that field cannot simply commercialize that technology without dealing with the federal government. So what can human rights really add? And let me just say that, that in my view, there are some important dimensions of the intellectual property human rights interface that we need to pay important attention to. First of all, human rights are both procedural and substantive. And so one of the challenges in many of the efforts to resolve the tension between human rights and intellectual property is that developing countries are often not at the table. Local producers of pharmaceuticals are not at the table. Those who would be able to, if the right were conceived as a right of access to know-how, are often not involved in the negotiations, either over the licenses or over the pledges, et cetera. And so one way to think about this is that human rights offers, and in fact, perhaps demands, an opportunity for participation by local actors in the negotiations over the tools that facilitate access to medicines. Secondly, human rights are often directed to the state, but recently international organizations, many of whom have participated in the Open COVID Pledge, are also the focus of human rights obligations. And so we have seen an expansion of human rights, not only to states, but to multinational corporations, as well as to individuals. And so in addition to the right of participation, those who hold duties under the human rights framework have also been enlarged. And then third, human rights could act as an anchor to limit the influence and the reach of multilateralism as the only way by which welfare is measured. And I think that is a possibility that we need to examine. My critique of the human rights frame has always been focused on the internal tension within human rights itself. In other words, the hierarchy of human rights has tended to focus on civil and political rights, and these rights have often historically gotten more attention than economic, social, and cultural rights. And that means that when it comes to access to medicines, which is often viewed as one of the economic, social, and cultural rights, there are enforcement challenges. And so even though Article 15 and Article 27 both speak to the right to enjoy the benefits of science and technology, there is no inconsistency patently between the intellectual property system and the right to enjoy the fruits of that technology. Many of the barriers to access to medicines have to do both with know-how and with price. And so it becomes necessary to ask the questions about competition law and other legal regimes that would work in tandem with the intellectual property system, that countries have an obligation under the human rights regime to ensure that these corollary regimes are in fact making the security of the human rights objectives possible. And so one benefit of the voluntary patent pledges is that human rights obligations increasingly, as I said earlier, hold corporations liable. And so these pledges ought to be valued and ought to be noted as a way in which those who are pledging their patents are consistent with the human rights obligations that they hold. And so now that we recognize corporations as subjects of human rights, these corporations can also lay claim to human rights. And that means that the tension over the appropriate role and limits of the human rights framework is already embedded in the interconnectedness between these two regimes. So to George's point about what do we do with companies who say may want to withdraw perhaps from the pledge, could human rights obligations be deployed to say, well, you've made this commitment. As a matter of human rights law, you ought to stay in it. You are both a duty bearer and a rights bearer. let me also point out that the sources of the human rights objectives are shared between the human rights regime and between the intellectual and the intellectual property regime. So within the US Constitution, the intellectual property clause, we also have national charters like the African Charter of Human Rights, the European Charters of Human Rights. So it's not just the global legal regime, but we now have replicated these regimes at the national and state levels. In other words, the source of the norms that might be leveraged to talk about access to medicines goes beyond just the Universal Declaration and goes beyond the international covenant. So a couple of principles as I wrap up here, I wanted to emphasize that with respect to the intellectual property end of things, every country has obtained technology by some combination of free riding, innovation, and trade. And so it's important as we think about access to COVID-19 vaccines and other medicines that the particular means of access that is dominant will depend really on the landscape in which we are competing. And so access to educational opportunities, access to housing, there are other dimensions of human rights that must come into play when we think about the capacity to, in fact, absorb technology necessary to address access to medicines. And so I think that human rights treaties should be viewed as an additional filter for the procedural and substantive IP norms that affect access to medicines, and they can be used to measure the distributive ends of the IP system. Regional human rights courts, we now have a decision from the Kenya Supreme Court invoking the human right to health as a limit on the right of patentees to block generics under regulatory systems available in Kenya. And so you see a dynamic interplay between human rights as a source of the right to health, intellectual property rights as a source of a right to the economic interests at play in the patent, and the use of human rights to say you cannot block the generic. In other words, human rights becomes a limit on the kinds of private agreements that patent holders can make with generic firms. Of course, in some other jurisdictions, this is done through competition law. As the UN Special Rapporteur's report indicates, human rights can also be a source of quasi-legal pressure, making sure that states are thinking about ways in which to limit the economic rights. I'm going to skip through these because I think where I want to end is that there is a new opportunity in which things like the patent open COVID pledge, patent pledge for COVID vaccines opens up a room for us to think, as Jordan mentions, about doing this in other fields. There are new actors, new kinds of economic behavior, new terms of sociopolitical engagement. The open pledge note in its unique kind of configuration does not have geographic boundaries. And so there are coalitions of scientists and innovators and manufacturers that could come together to ensure that access to medicines remains consistent both with the IP system and with the human rights regimes. But I think the bottom line is that the cultural and economic and legal considerations at play in the field of access to vaccines in particular demand a more expansive view of welfare than what we can see currently in the intellectual property regime by itself. Two final points. Also exemplified by the Open COVID Pledge is that we're seeing a mixture of global and local actors. Terry Fisher and I and Padma Gale in a recent article spoken to the need for local manufacture, which must build on accessibility to the knowledge available through patents that have already been made available. But these coalitions emerging across geographical boundaries are going to be critical in integrating the frames of human rights and intellectual property. And ultimately, I think what we're seeing is that both the human rights regime and the intellectual property regime encompass concerns about innovation and freedom that makes it impossible, for good reasons, for intellectual property and human rights to operate in silos. The integration of these legal regimes create both the opportunities for participation and the opportunities for states to be pressured to think about legal regimes that can coexist meaningfully with the intellectual property system to ensure that access to the know-how, access to the medicines, and access at affordable prices is more of a reality than it has been in the world since 1994. And with that, I will stop. Thank you so much.
Thank you very much, Ruth, for the brilliant presentation, and as always, extremely well-rounded and comprehensive on all the nuances involved and the complexities involved. Let me now turn finally to Srividya Ragavan, who will discuss a different angle on healthcare access, primarily also from an institutional standpoint. Let me turn over to Sri.
Hi, can you hear me? Can you hear me?
Yes.
Yes. Okay, thank you. I wasn't sure. All right, thank you. It's always a pleasure to follow Ruth. I follow Ruth to Oklahoma, and it's I follow all of her work, so it's always a pleasure to speak right after you. And I very much enjoyed Jorge's presentation as well, something that I've been closely following. So my presentation now would be on global justice and healthcare access, right? So to me, the idea of trade with intellectual property, has taken a completely different framework post-COVID. Pre-COVID, trade dictated public health. So several efforts, even fair negotiated efforts to protect public health, was considered a barrier to trade, and that happened repeatedly in different ways. And in some ways, COVID has really created, the impression that public health dictates trade. I mean, look at the supply chain disruptions, right? So there is no trade without public health. So that's one of the biggest lessons, I believe, that COVID has left us with. In some ways, if we have to reconcile this has not been a new theme, right? Several scholars have been talking about it. Developing countries have been talking about it for a long time. If anything, I see that the number of academics engaged in this thought has, over a period of time, expanded, right? I remember when I was a younger, when I was a young faculty, so to speak, when Peter Hughes conferences, I used to be the one international IP panelist, and then it became two, and then it became a panel, and then now, of course, we have separate international IP conferences. So this is not a new theme, and a number of people see the uncomfortable arrangement between trade and IP affects public health, and also how the vast impact that it has had on healthcare access, right? But it had remained unpopular, of course, and I tend to think that its popularity has increased post-COVID, essentially because of its impact on the developed world. I mean, suddenly I see there's a lot, there's much more sort of a reconciliation in the developed world. Much of the developed world, especially in the United States, of how this can impact a lack of global public health, or a tethering global public health can affect us, so to speak, right? So to me, access to available healthcare is global social justice, right? It's hard to tell somebody in another part of the world, well, I'm sorry you have this disease. There is, medication available in the US, but just too bad that you can't access it, right? So to me, that, that does not comport with the right to health, right to life, right? And the whole idea of global social justice. And this is not a moral argument. More often, very uncomfortably, this has been couched as a moral argument. This, in fact, is not a moral argument. It is, in fact, a legal obligation. This is, to some extent, a negotiated obligation under TRIPS as well, especially with the Doha Declaration, especially with much of the, Article 31Bs, etc. This is a negotiated obligation as well. But most importantly, right, as a country that tries to export democracy to the rest of the world, this is part of the sovereign responsibility and part of the sovereign responsibility in every democracy, right? And it is part of the correlative obligation, which is so central to the ideological framework over which we couch intellectual property rights, being Bentham's theory, right? So it is part of the correlative obligation, and I've written about this earlier, and this obligation is really something that the inventor provides as part of the disclosure, as part of the public benefit end that the patent system seeks to achieve in exchange for the monopoly rights. But if there is, and I borrow from the climate studies here, but if there is one big area or one big gaping gap, so to speak, it's the attribution gap. We have looked at the study several times from the ideological framework of the Western system. So there is a large attribution gap wherein we don't really have sufficient studies on how lack of access to healthcare in developing and least developed parts of the world affects productivity, and how in turn that affects global productivity and innovation. So we don't have sufficient data on that. Right. So now when we talk about global justice and IP as a framework, intellectual property as a framework, right, we then naturally start to talk about the barriers, the different forms of intellectual property rights as it works with the trade regime has in fact been a barrier. It has been called as such by United Nations agencies. The WHO has decried the role of IP in healthcare. So that it is a barrier now is a factual and not an argumentative proposition. The other less focused aspect of it, about which I've written, is the with Jonathan Kimball, is the regulatory exclusivities, which stacks up on the patent regime, on the IP regime, and really, further bolsters private rights, to public detriment more often than not. So when we look at IP as a barrier, and I think Jorge talked about it too, much of the discussion revolves around patents, right? Patents over suspected inventions, the narrowing of the non-obviousness doctrine, the prima facie non-obviousness doctrine, the TSM, the teaching, suggestion, motivation doctrines. All of these are examples. Several academics have written about this, and of course, KSR has tried to put it back to some extent, but that's one side of the spectrum. The stacking up, the evergreening of patents, the secondary patents, pricing and patents, public funding to create private property. These are all things that have also independently and collectively impacted access to medication. So I want to talk about all of these three in the next slide. But patents are not alone the barrier. Copyrights, trade secrets, about which we talk a lot with the IP waiver, have also been a huge waiver, right? A huge barrier, right? Especially with the advent of AI technologies, it's not just copyrights and trade secrets, but also regulatory exclusivities. We don't need the kind of time that we needed to create clinical data, right? And so AI has made it supremely easy. So then why do we need 12 years of protection of the data for some biologics when that data can actually help much better to deliver much better treatment and cure. But on the question, I go back of the secondary patents pricing and public funding. I think, I like to show the slide as an exemplar, right? If we look at this particular slide, and I'm going to use this, right? All of these are high value drugs. These are blockbuster drugs, right? Look at the number of patents that these drugs have, right? Humira alone has 132 patents covering it, right? The number of applications is at least 4 times more for Humira. It's 400 and something for Humira. And the same with Lyrica, it has about 68 patents. All of these, of course, are on the same spectrum. Now that comports with the increase in prices over a period of time, 163% price increase for Lyrica, and in April with 155% increase in prices, right? And this is another example of how even when the primary patent expires, other active patents have remained in the market. Other examples, of course, one that's very close to me is the price that Bayer originally charged for Nexavir in India at a $62,000 per month's supply in India, which is a high price even for middle-class people living in the United States. Well, even for upper middle-class people living in the United States, there is no way, right, in a country where only 15% of the population have insurance, which is India, right, this kind of price tag would be affordable. Public funding, of course, this is another big issue. All of us are aware of it. Moderna now, which is in the thick of negotiations to see if they could pledge some of their patents, which is also talked about pledging, but which is also in discussions right now for more things to happen, right, benefited from a whopping 5.53 billion. And that goes for many of these companies, right? Merck, which negotiated with the MPP just last week, also received in the millions, but it did receive with Emory University some funding as well, right? But these things take us closer to a price system, right? An incentive system that probably makes us consider, a non-IP framework, which is the most important thing that we have to talk about. Right. I already touched on regulatory exclusivities, but I just want to add that when we talk about regulatory exclusivities, it's not just the protection for the data. It's also the market exclusivity that's stacked up on top of the data exclusivity. And then, of course, the orphan drug protection, which Gilead tried to use in 2020, in the thick of COVID, for remdesivir. These are all examples of how these different kinds of exclusivities have created a ticket that has worked within the trade and IP regime to make access difficult, right? So within the IP regime, there are negotiated solutions, but I don't want to go into it except to say that they have proved time and again to be inefficient and not always timely. The one that is being, that is being talked about now, especially with the MC'21, is the waiver. I like the waiver comparatively, partly because it covers all IP. It sets a great precedent. It works within the system for now, but that does not, between these two, I like the waiver, but that does not take away the fact that, that there is a need to de-link IP from trade. For far too long, right, IP and trade has existed in a very sort of uncomfortable marriage, right? So it's time to look at other sort of frameworks, where these two can work in a more sort of compromising fashion, all right? So what would be the goal? I mean, to even think about de-linking IP from trade or to create a new framework, what would be the goal? To me, the goal would always be the local production, right? So if we can kickstart innovation, so de-linking IP need not mean de-linking innovation, right? But it certainly has to mean that we should empower some of these countries to raise into the innovation spectrum. So local production it does comport with some of the objectives of the IP regime, IP and trade regime, Article 7 and 8 promises as well. More innovation, but more process-oriented innovation, something from which we kind of moved away. I think we have to relook at some of those as part of any system that we might want to consider, right? Where do we look for solutions? One is, of course, the economic efficiency regime, right? The need for improving global productivity, right? And to measure it from a national perspective. When we look at global productivity, we look at it more sort of together, how global productivity ends. But in each nation, right, is it sustainable? Is national productivity proportionately increasing? And of course, redefining the value of what we, how we define innovation. Access should form a part of the value that we assign to some of these innovations, right? And of course, the other area from where we can look at solutions, or we can, try to draw solutions from, is from the political science, policy and regulation approaches, right? So from a purely sort of existing IP model perspective, which is also in some ways the economic, in some ways, not always, the economic efficiency perspective, right? I tend to think of patent pools. We've talked a lot about patent pools. The MPP is working with Merck to create, is a great example of how a patent pool is currently working and doing well with COVID vaccines. Differential pricing. We've talked about differential pricing in the context of between nations, but I think economists from Stanford have also talked about differential pricing as a part of the trade framework. But I like to think of differential pricing as something that can happen within a national context. In a country like India, where there's a huge gap between the rich and the poor, maybe it's time to think about pricing within differential pricing within a country, right? Pledges, Jorge talked about it, different forms of licenses within and outside of these pledges. Waiver, these are all some examples of within the existing IP model, more sort of hybrid, right? Which is strong benefits, and in some cases also some issues, right? So to the extent that we continue to have our ideological affinity, I think we probably have to redial and look at the value proposition a little bit differently, right? And that alone will take a lot of time. How we look at the correlative obligation, not only from a property perspective, not from a natural rights perspective, but more from a, more from a contractual perspective, which is now taken on a sort of a diminished approach or value in the patent and IP framework. So that's one of the things that needs to be done as we go forward, I assume, right? And it's also in some cases hard to get to the universal goal individually. I like to think each of these solutions are viable. Each of these solutions are working, but collectively, it has to be presented to the globe as part of a package or a repertoire of options, right? From which different countries can choose from, right? But this is not the only end, right? I mean, you also have other approaches outside of the IP models, like grants, prices, public funding, right? The health impact fund and the green impact fund, I like to think fall within this approach, right? It delinks value from the market to some extent and delinks it from the cost of production, right? And instead provides more value to, say, therapeutic efficacy or the efficiency of actually creating access, right? To some extent, this shows a slight shift from the ideological attachment and has the benefit of including solutions that are both ex ante and ex post. And so these are the other sets of models that we see, right? And of course, for the policy-based approaches, where we look at the political science policy-based approaches, I, in particular, have been a big fan of both the India model as well as the Brazilian model, right? They have proved that it's workable. It also has strong historical bases from, from what happened in the 1800s, from the development of the German chemical industry and so on, right? So I like to look at the process patent as a viable policy tool to kickstart local production and innovation, right? Say countries in Africa and parts of the world. I also like the 3-year compulsory licensing term, right? With burden on the company, on the pharmaceutical company, on the innovator to show that, look, if you are unable to supply the market reasonably within 3 years, then the risk of the product going into compulsory licensing is very high. It's also important to consider segregating therapeutic versus blockbuster drugs, right? For example, nobody cares if Viagra, well, I hope at least that nobody would care, right? If Viagra falls through the classic patenting system, right? Whereas Lipitor should become a little more, or should be something that's much more accessible. Same with imatinib, same with Humira. Some of these drugs should be much more accessible, whereas Botox and Viagra probably could go into the classical system. And of course, the idea of how we deal with within a country differential pricing, right? In and itself presents a robust area of study, and that's another policy-based option that a country, based on its local needs and local issues, should be able to create for itself, right? So given these these various approaches and this repertoire of choices, I like to think of a solution that presents these options to individual nations. So I like the idea of a public health treaty, right? So the public health treaty, in my mind, right, should be where the burden is on a country, on every individual member nation, right, to ensure that there is national public health is safeguarded by ensuring access without really compromising innovation, right? And that should be the groundwork for global public health, right? It should in some way move away from unworking, and Ruth also kind of alluded to this, right? The uncomfortable sort of marriage between trade and intellectual property rights, right? It should, of course, incorporate local manufacturing and good global practices. I want to highlight the Bayer decision from India. When Nexavar was compulsorily licensed in India, right, one of the paragraphs talked about local manufacturing because Justice Srividhya thought that Justice Srividhya interpreted TRIPS to include the local manufacturing flexibility. And of course, almost the United States, the EU, all of them pounced on that particular line and said that local manufacturing is not part of the negotiated flexibility. So those kind of things, I believe that local manufacturing should be specifically enabled. We're doing that with COVID, right? Africa just received a $2 billion grant from the WHO. Bangladesh wants to set up local manufacturing. So those kind of things should be enabled as part of the solution package, right? But I like the idea. The chat forum was talking about the idea of UN. I like the idea of institutional oversight, international institutional oversight, but with national responsibility. So, for instance, however idealistic, it sounds, I believe that the WHO and WTO should work together, right? So, to me, a public health treaty would provide a medley of IP and non-IP framework, a set of flexibilities for countries to work with. And as part of that flexibility packaging, countries will take the ownership, right, to ensure that there is public health and there is access to public health, right? And in this, I kind of allude to what, to Stiglitz's theory, right, which is that individual nations are best positioned to take stock of problems and solution options, right? And when we talk about this, there are two separate policy options. One is health policy, right, where access and innovation form important elements. The other is, of course, innovation policies, right, where it's important to provide funding, but important to ensure that the obligations trickle down as public benefit, right, to share technology in a manner that the benefit is perceivable in the healthcare realm to all people. It cannot be like, oh, you know, if you have cancer, you just have to wait for 20 more years and we'll give you the solution for cancer, right? It has to be a sort of a obligation to ensure public benefit, right? National policies should be based on local realities. So the flexibilities are important to accommodate, right, to local realities that are different, and there is no one size fits all here, especially in healthcare. So there's a need to do that, right? And policies that promotes and furthers local productivity, right? So with that, a public health treaty could put the global public health in the appropriate context with ideology and within the realm of the trade framework that we have now, right? So without compromising trade, right? The only thing I want to emphasize before I get off is that healthcare should not be a byproduct of charity of rich nations to poorer countries. That's not what health diplomacy is. That's not what human rights healthcare access is. It cannot be a byproduct of charity, right? If anything, our talent capital, talent pool that globalization has, has brought together shows that there is hidden talent in every part of the globe, right? And so it should, in some way, kickstart and use it appropriately. Global productivity should happen from good governance for global justice from a sort of a broader perspective through access to healthcare. So with that, thank you for the time, and I'll wait for the questions. Thank you very much.
Thank you very much to all our speakers. I'm mindful of the time. There's 10 remaining minutes for questions to be put forward. I can see that there are already comments in the chat, so perhaps I can ask Aidan Hollis to sort of lead us in any discussions in relation to any of the three presentations.
Sure. I wonder whether I could actually ask about the differences in how policies might be applied between large and small countries. India is just not typical, for example, of most countries in that it has enormous capacity and is really large. The policies that apply in India might not be at all applicable, for example, to Gambia. And I'm just wondering, kind of looking across the range of policy discussions that we've had, whether there are really differences that we need to think about between large and small countries.
That question
I think
for me?
that's you. Yes.
Yeah. No, absolutely. And that is, in fact, the case. I mean, India is only one example. So that's the whole idea of providing the repertoire of choices, right? So what works in India did not even work in Brazil, which is comparable in some ways, right? Or even South Africa. So the idea is, each country is on a different spectrum when it comes to both access as well as innovation, right? So the idea is to empower countries like, certain African countries to get onto that map of innovation, to stop only being importers of medication, while countries that are on the verge of innovation should move on to the next spectrum, to the next level of development. And so the idea is to provide a range of choices for national leaders to implement to ensure access. Does that help at all?
I'm thinking of it a bit more broadly about whether actually, I mean, some policies like local production, these are just not realistic solutions for very small countries. So, that has to be kind of thought about. And I don't know whether there are also different considerations even across the kind of broad range of thinking about IP and health, whether actually maybe, small countries might often need very different solutions.
And that is the case right now, right? Small countries do get different solutions. The idea is to, when we talk about enabling local production, I agree that not all small countries can become producers within a day, but the goal should be to enable each country to take care of some of their health needs in its own way. And if they are exporters, I mean, it's not that every country has to become self-sufficient. I mean, that doesn't help really, but to tap into some of the resources that each country can bring to the table, right? As opposed to the system we have now, where innovation happens in one part of the world, and then the other part of the world is kind of in the medium spectrum. And then there's a third, the third level of the globe that just relies on these two developing and developed countries. So that, that sort of pyramidal framework should be replaced, is what, is my larger, broader sort of thought there.
Thank you. Perhaps if I could move the discussion a bit further. I mean, one of the things I'm really grateful to our speakers today for illuminating various perspectives. The three different models from Professor Contreras, from Professor Okediji, and Professor Ragavan focus on different mechanisms in which the human right could be implemented one way or the other. And they have relative strengths and weaknesses and questions on suitability and fit from a standpoint of also considering regulatory autonomy, also considering competing demands of innovations. And so to the extent I appreciate that in the open COVID pledge, there might be a model that works in restraining the enforcement of patents voluntarily, where it's a private sector driven initiative, as opposed to a state driven initiative, an instance where corporate actors voluntarily take it upon themselves, wittingly or unwittingly, to advance human rights objectives, such as health, in a case of not enforcing patents in such a strict way. But also going to what Professor Okediji was talking about in regard to the human rights. I mean, part of what my clarification there is, when we look at human rights, do we really just look at the Article 15? Do we really just look at the right of access and participation? When we talk about the right of access, why don't we also talk about larger consequences, such as the right to life, which is a civil and political right, and the right against the arbitrary deprivation of life, or the right against non-discrimination, which is a cross-cutting right for both civil and political rights and economic, social, cultural rights. So the way that I would ask all three speakers, and anybody's free to jump in, if we're looking at human rights, not just from the standpoint of the implementation across different channels and the models, the three models that have been presented, what are your primary considerations for which rights or which values? When you look at human rights as values one way or the other, whether we value the right to health, or whether we value in particular non-discriminatory conduct as guides for policymakers, as guides for regulators, what values in particular animate your preference for, say, a private sector driven option, or a redistributive option, as is what appears to be the case from Professor Ragavan's presentation, or in Ruth's presentation, something that looks at addressing the participation and dimension aspects, but may not necessarily address any other human rights aspects. I mean, what values are primordial when you look at the fit? I mean, you look at the suitability of the mechanism that you're putting forward. And perhaps I can start with Professor Contreras.
Great. No, thank you. And also thanks to Ruth and Sri for really illuminating presentations and a lot of aspects of this that I had never thought about personally. So I thank you for that. I mean, I have to say, I mean, from the sort of the voluntary pledging world, we took this approach out, looking at primarily at the value of pragmatism. Right. I mean, I do not disagree with any of the other approaches that have been discussed. And I would, be the first to sign, Professor Ragavan's global health treaty if I had any signing authority for anybody. But I mean, I think we all know how long these intergovernmental processes take. And, you know, as I said, we have been working with WHO, with the CTAP, and, you know, a variety of other intergovernmental programs, and they're not fast. And so I do think that they're, you know, I think that pragmatism and sort of immediate effect is something that is legitimate to you know, put in the calculus. And you know, we didn't achieve 100% results, but I think we achieved something. And so as an interim, like immediate stopgap measure while these other processes move forward, I think is something that I don't think often enough is part of this discussion. And so, you know, hopefully that's really where we were coming from.
Thank you so much. And Professor Okediji, are you still online or are you at class already? She might be in class already.
I think she's still, at least still showing in the gallery.
Possibly she might. Professor Okediji?
She's.
Okay, let me turn to Professor Ragavan. It might be a possibility that she was already heading for class. Thank you.
Sorry, I was waiting for Ruth's response. So I just want to add to what Jorge said, and also to Aidan's response. By no means will this be an easier solution. By no means is this the idea of a public health treaty that considers health separately is an immediate solution as well, right? So I believe that the pledges pools, they're all working to some extent, right? And I also favor the waiver as a possible immediate sort of solution to COVID, right? But in the larger framework of things, as we move forward beyond COVID to a world where healthcare access becomes sort of a, you know, we look at healthcare access separately and as part of the global justice paradigm and as part of the right to life, human rights paradigm, I think we need something that, you know, that sort of conceptualizes it and then brings it together in the form of a separate treaty. And to some extent, that's also a conclusion that this uncomfortable arrangement in TRIPS that we've seen has not really worked. I mean, even before COVID, I think because of the WTO's internal problems, I think the WTO was losing much of its strength, right? COVID has only made it worse, right? And if anything, you know, the need to work with WHO, which the WTO is struggling, right, in a lot of ways. As much as I love folks at the WTO or the WHO, that's proven to be a very difficult task. But I think for a more sort of a broader framework, you know, an approach that's more long-term should be looked at.
Any further comments or questions, Thomas?
Yeah, I wanted to say this. I think of human rights not only as values and guides, but also as constraints, as sharp constraints. There's certain things that you simply cannot do. You cannot torture people, for example. And I'm wondering whether that fits in some way. So think of a country that says, we are going to put a 500% tax on foodstuffs. So anybody who buys food, you know, there has to be a 500% tax added. And the very predictable result is that a lot of poor people starve to death. They can no longer afford food. Now, that's a case where the good is very important and where the barrier that's being imposed is a very substantial barrier. And I think I want to say about such a case, this is a clear-cut violation of human rights. Now, going from there to the pharmaceuticals is not a very big step. In 1995, we passed the TRIPS agreement. In 2005, it became operative in the less developed countries, including India, which was the pharmacy to the world. and prices of pharmaceuticals, including life-saving pharmaceuticals, jumped. There were manufacturers very willing, very able to provide these pharmaceuticals at low prices to Indian poor people, rich people, everybody in India, and to people throughout the developing countries, which had all had weaker intellectual property regimes before. And from one day to the next, that door was shut, and these manufacturers were told you can no longer supply these medicines, and patients were told you can no longer buy these medicines at such prices. So if there is a human rights constraint, if we can say about this development, you just can't do that. That was contrary to human rights, a violation of human rights, then I think the next step would be to say, if you want to incentivize pharmaceutical innovation, you have to find another way. This is not a viable way. This is just not legal.
And if I could add to that, I mean, there's a lot to be said, of course, that human rights fundamentally is a constraint on states. That includes a constraint on state action and how they legislate and how they regulate. And in the first instance, how they enact policy, to the extent that in my own work, I've reflected particularly on economic, social, cultural rights. It's not just about human rights implementation, but human rights accountability of states. But let me introduce and advance the discussion a little further, because we are talking about the corporate sector, and I'm glad that Professor Ragavan brought that in. We recently had landmark cases and decisions on the business and human rights front, particularly probably the most consequential one, Milieu de Vinci versus Royal Dutch Shell, which was decided by the Hague District Court, holding Royal Dutch Shell liable, not just for a duty to respect human rights, but also a duty to protect human rights. Originally, under the business and human rights framework of John Ruggie, the duty to protect is vested only in the state. But where now the local courts, various national courts from the Netherlands to England to with the Vedanta cases and a number of litigations pending around the world on climate change and human rights, where the trend is going, the duty of care of the private sector is expanding. That may expand especially on immediate urgent cases that involve greenhouse gas emissions, that involve threats to life, existential questions that implicate the human rights of populations and stakeholders and markets and communities and consumers that are served by corporations. So to the extent, and I'll address this to both Professor Ragavan and Contreras, to the extent that we're seeing this incremental shift to sort of expand the duty of care of the private sector, isn't it actually to the advantage isn't it ironically an incentive on the part of the private sector to anticipate the development and themselves proactively already start thinking of models beyond the existing framework of trade or the framework of TRIPS, or in this case, if it has to be a voluntary sort of expansion of the open COVID pledge?
Yeah, so I'll speak briefly to that. In the list of rationales that companies have to make these voluntary pledges, there is certainly a set of pledges that are made in order to stave off pending governmental action or to appease regulators. And I think that's quite clear. And though, and I have speculated in my writing that this may have something to do with Moderna's pledge of its mRNA patents in the COVID-19 area. It was involved in disputes with NIH and with DARPA about the ownership and the legitimacy of some of the rights that it claimed. And so it seemed at the time like it was expedient to just pledge these rights and essentially get the government to stop it. Those disputes have reemerged in the last few weeks. And so it'll be interesting to see what happens there, especially in terms of NIH. But absolutely, I think that the threat of government action can and should motivate private actors to behave better. So I wholly agree.
So maybe just to follow up on that, if the threat of government action is so efficacious, and indeed human rights is supposed to be a constraint on that government action, how do we move the needle with the states themselves to start? And maybe this goes a little bit to what Professor Okediji was discussing earlier. I mean, to the states themselves that have the primary duties to protect, who may, for better or worse, are not exercising that primary duty to protect, are not constraining or using their power to constrain through regulation in the process of trying to encourage innovation and trying to stick with an existing model, or trying to basically navigate competing property interests with the human rights interests of its own population. I mean, to the extent that this is also a state regulator problem, what can move the needle? I mean, if it's another public health treaty, Professor Ragavan, that's another issue of how do we enforce the treaty and how do we hold them accountable for that? So where do you think there could be some effectiveness in nudging the regulators to do their job and to remember that part of their mandate also includes that constraining force of human rights?
So I'm a bit of a pessimist, right? So I think I don't believe that naturally, right, the private corporations have a tendency to be more public friendly, right? Much of what we see here, I believe, is because of non-governmental organization action. To some extent, academic actions as well, but mostly I give credit to non-governmental organizations also to that to what we see. But I want to allude to Ruth's paper, to Professor Okediji's paper on this, right? So where she talks about how the trade regime in and of itself became a conduit to sort of corrupt government officials into the IP regime to their own detriment, right? And how some of these poorer countries bought into the IP regime and then worked it into the into the healthcare framework and created more rather than less issues, so to speak. We see that happening with Bharat Biotech in India right now, right? Even though they came with a version of their mRNA vaccines, they found it really difficult. So we see that with Bharat Biotech. I tend to believe the world is much more Hobbesian. And so at some point, whether we use any of these, whatever framework we use, or the medley of framework that a public health treaty could use, should actually incentivize governments, right, to put healthcare in the center as part of some of the things that they actually can access from that. Does that make sense at all? Right? It is like trade at the end of the day, right? So you have a good healthcare system, then you can get some other benefits from global trade, right? So
I think on that note, I can see we're at the top of the hour. Let me extend my thanks to our panelists, Professor Ruth Okediji, Professor Jorge Contreras, and Professor Ragavan in particular, especially on the 3 different models and perspectives to really examine how human rights can be realized, but can also be enforced, and to hold states as well as other actors that violate human rights, particularly companies that hold the monopoly of rewards, to think about that as a man-made creation first and foremost, and whether or not what the ultimate development consequence is, and that's my primary area of interest, whatever model or framework or regulatory system is devised within the patent system or outside the patent system. For me, the overriding question remains why we design these systems and to what ends and to what goals. And if the goal is to ensure the realization of the interdependent human rights, not just the narrow confines of participation, but all of it, the right to life, the right to health, the right to an adequate standard of living, then maybe we have to be thinking more laterally about the kind of incentives we're designing. On that end, I'm going to turn to Thomas and thank him for convening this panel.
Well, the thanks have to go to you for doing it. It was, I think, a fantastic panel, and we will post it in a relatively short order for posterity and the rest of the world who were missing it.